When it comes to the law, we want to know exactly what we need to do to be in compliance with the law. So to make sure that we are not in violation of the law. We see this everywhere, right? Right now, with cryptocurrency, this is something where it's an ongoing problem, is that these different entities don't know what exactly they need to do to be in compliance with the law. And with accessibility, we've seen that as well. We've seen a scenario play out over for the better part of the last decade where people want to know exactly what they need to do, but we don't have explicit requirements that we where we can know exactly when we are in compliance with the law. And so, with proposed bill AB 1757 in California, we would seemingly have that because AB 1757 incorporates the Web Content Accessibility Guidelines version 2.1 conformance level AA as a standard for accessibility. So it effectively requires full conformance with WCAG because there's no qualification to it. So WCAG 2.1 AA seemingly provides us with that objective um, requirement that we are looking for. These are technical standards they're from the World Wide Web Consortium or the W3C under their Web Accessibility Initiative. They are recognized around the world as technical standards for accessibility, and really, they are the standard. So um, we have the explicit requirements, except for when you break down the Web Content Accessibility Guidelines and you understand what comprises them, and you start to examine and evaluate the different requirements under these guidelines, then full conformance is not so easy, and very difficult legal situations are presented. So it's important to understand that there are 50 things to do for conformance under the Web Content Accessibility Guidelines version 2.1 conformance level AA. There are different versions and conformance levels, but that's the focus. So sometimes it's easy to know whether we've met a requirement under these guidelines, but other times it's not. And sometimes this is because these guidelines are highly technical, but many times it's because there is subjectivity involved in determining whether conformance has been achieved. And this can present some difficult legal scenarios. So, for example, when are closed captions accurate enough to be considered sufficient? Success criterion 1.2.2 requires closed captions, but what if our closed captions have continual misspellings and the acronyms are wrong, and there's no punctuation, and the closed captions also don't include any of the important sounds that are made that are meaningful to the content. So when are closed captions accurate enough? Are auto closed captions enough? This is one of the legal scenarios where it's arguable because there are levels to closed captions, and it's difficult to know at what point closed captions are not accurate enough. Now, certainly there are situations where we can look at certain closed captions and we can say definitively that these are bad closed captions, but it's not always easy to determine when closed captions are accurate enough. Also, when are alt text descriptions concise and descriptive enough? We want alt text descriptions to be descriptive, but at the same time, we don't want them to be any longer than they are. So it can be easy for there to be situations where there is an alt text description available, but maybe it's so basic that it's unhelpful and it doesn't fully describe the image. So again, we're in a situation where we need to work through whether an alt text description is sufficient. What about color contrast? So we know what the minimum threshold is under WCAG 2.1 AA for color contrast. But what if we have some text in our footer that is too light of gray and it's only 4.2 to 1 contrast? And so we're not at that 4.5 to 1 contrast level. What happens in that scenario? Does that mean that a person with a disability has been discriminated against? And does that mean the website is inaccessible? right? So you start to understand that there are all these different success criteria, but as we look at them and analyze them, we can be presented with these difficult scenarios. Also, on the screen with me, I have the official documentation for the Web Content Accessibility Guidelines, and I will link to it below. And I'm going to scroll down this documentation, and there's an abstract, and it's quite a lengthy document. There's a status of the document, but then there's also a table of contents. And then so there's an introduction, and then there are these different sections, and that the Web Content Accessibility Guidelines are organized under. So there are perceivable, operable, understandable, and robust are the different sections. And these are principles that the Web Content Accessibility Guidelines are built under. And so there are many success criteria organized under these principles. And for version 2.1 conformance level AA, there are 50 success criteria. This document has even more because it also includes the AAA conformance success criteria. But the purpose here and what I'm showing on my screen is that there are many success criteria to work through when we are looking to the Web Content Accessibility Guidelines for conformance. So it's not always easy to know if your web asset is conformant. And I will continue along with these these more difficult legal scenarios. So with success criterion 2.4.4, link purpose in context, it reads, the purpose of each link can be determined from the link text alone or from the link text together with its programmatically determined link context, except where the purpose of the link would be ambiguous to users in general. So this is getting at the anchor text links that we have, and we want to make sure that they are descriptive enough to so that the user understands what the link is for, and so what the purpose of the link is. But when have we made the link descriptive enough? Is one word sufficient? Do we need two words? Also, will plaintiffs' lawyers bother to look at this second part of the success criterion where it says, or the link text together with its programmatically determined link context? So this could mean that we have the word here linked at the end of a sentence, but the word here, what the meaning is clear based on the text that precedes it. So something like, to go learn more about this product, click here. If we have click here linked, by itself, the purpose of that link is not known. And so, but in together with it, the context, it is known. So this is a situation where I can definitely foresee plaintiffs' lawyers looking and finding that text and then deciding that that text was ambiguous and did not meet the success criterion. Or they might not pay attention to this other part, this exception to the success criterion, except where the purpose of the link would be ambiguous to users in general. So there are multiple layers to this, and it's important to evaluate this success criteria and to understand it. And I don't think, and what I've seen play out in complaints is that there are many instances where plaintiffs' lawyers don't understand the accessibility claim that they're even making. So I've tabbed over to success criterion 3.3.3, error suggestion. It says if an input error is automatically detected and suggestions for correction are known, then suggestions are provided to the user unless it would jeopardize the security or purpose of the content. So what this is getting at is if someone has made an error in inputting data, then there's an error alert returned, and then there is a suggestion to correct that error. So when are our suggestions sufficient? So just because we've made a suggestion doesn't mean that we are conformant with this success criterion. And at what point do we know that our suggestion is sufficient enough? Tabbing over one more time, 2.4.1, bypass blocks. A mechanism is available to bypass blocks of content that are repeated on multiple web pages. Now, this is very short, but just from reading it, you know that this is very technical, and this is how technical the Web Content Accessibility Guidelines can be. What this success criterion is getting at is making sure that there's a way to for screen reader users to bypass the content, usually the header content that is repetitive. So this could be the navigation menu links. This could be the ads in the banner. This could be the social links at the top of a banner. All of the content that is in the header that is repeated, we want a way to make sure that we can skip to that and get right to the main content. So the traditional means of achieving this is with a skip link, because with a skip link, it shows up first, someone can click it and get right to the main content. But that's not the only way. And in fact, if you read through the intent section of this success criterion, it reads, most web browsers provide keyboard shortcuts to move the user focus to the top of the page. So if a set of navigation links is provided at the bottom of a web page, providing a skip link may be unnecessary. So let's focus in on the success criterion wording. It says a mechanism. So a mechanism doesn't necessarily mean that it needs to be a skip link, but most plaintiff lawyers, if there is not a skip link, they will focus in on that and then name that as an issue, an accessibility issue that they are claiming. So again, when you look at these success criterion, it is more than just simply conformance and a yes or no. There are different layers to this. Moving on to another tab, 3.1.2, language of parts. The human language of each passage or phrase in the content can be programmatically determined except for proper names, technical terms, words of indeterminate language, and words or phrases that have become part of the vernacular of the immediately surrounding text. So what this is getting at is if there is a change in language, that change in language is coded, is programmatically available to screen reader users. But what can become difficult is, when is there a sufficient change in language? What if there's a common phrase that is from another language that many people know, some may not? Do we need to have that change in? What if we forget the language change? What if there is again, we have a common phrase where from another language where we don't add that in, and where it would be helpful if we did. So if we are non-conformant with this success criterion, then what, right? Or what if, when is the level for every single foreign word or phrase? Do we need to make sure that we have a programmatically determinable language change in effect? So it can be difficult to know exactly when we need to have this coded in, but my point is that it's not always known, right? We generally know how to meet this success criterion, and we certainly know that for a long paragraph, of course, we would need to have a language change in place. But it's arguable in some instances because so many different foreign words or words from foreign languages and phrases from foreign languages have become a part of the English vernacular. It can be difficult to determine when we need to have language change, and it's certainly arguable from a plaintiff's lawyer's point of view if a language change has not been made, that plaintiff's lawyers may argue that every language change needs to be programmatically available. And then one more tab I'll get to is success criterion 3.3.4. And it says error prevention, legal financial data. For web pages that cause legal commitments or financial transactions for the user to occur, that modify or delete user controllable data in data storage systems, or that submit user test responses, at least one of the following is true: reversible, checked, confirmed. So submissions are reversible. Data entered by the user is checked for input errors, and the user has the opportunity to correct them. Or a mechanism is available for reviewing, confirming, and correcting information before finalizing the submission. So what this is getting at is we want to make sure that we can undo anything that could cause a serious error or something with implications that have serious consequences. And if we look at the intent here, so scrolling down to the intent section, it says the intent of this success criterion is to help users with disabilities avoid serious consequences as a result of a mistake when performing an action that cannot be reversed. For example, purchasing non-refundable airline tickets or submitting an order to purchase stock in a brokerage account that are financial transactions with serious consequences. So this is a very good success criterion. But when we read the intent, we can see it's for uh, transactions or submissions where there are serious consequences. So, given the success criterion, if we can argue that it could be argued that even subscribing to a newsletter could be considered something where we have data being submitted, and well, maybe that wouldn't meet the success criterion. So that wasn't a good example off the top of my head. But the point is that if we take this success criterion literally, we could apply it to every situation, really every situation where a user is making a legal commitment or a financial transaction. And some legal commitments are very nominal, right? They might just be agreeing to user terms and conditions that are maybe that they could have potential consequences, but practically they don't, because we're not reading all of these different notices and commitments. Also, for financial transactions, what about just for your common shopping cart or making a purchase for $10? That's not what the intent of this success criterion is getting at. Although I agree that we want to make sure that that would be reversible, and it usually is in e-commerce. The point is that we have a success criterion where if you take it to its literal end, then we can construe any number of situations that go away from the intent of the success criterion, where it can be argued that a digital asset is non-conformant. And so the point here is, and this goes on and on, right? There are several more success criteria that I can do this for. But the point is here is that it's difficult to draw lines. And it's important to note that the Web Content Accessibility Guidelines are not law. They're technical standards. So they're not meant to draw lines. They're meant to optimize accessibility. And accessibility is not A or B. And it's difficult to determine, this is getting back to the law. It's difficult to determine what results in a barrier to access. What is an inconvenience? When are there too many inconveniences? What is something that is above an inconvenience but below an outright barrier to access? And so this is what I'm trying to get around, is why it is so difficult to craft a law around accessibility. So of course, WCAG 2.1 AA is conformance is best practice. And eventually when 2.2 rolls out, then 2.2 AA conformance will be best practice. So that's still recommended. And it's a great reference for compliance, but to fully incorporate the Web Content Accessibility Guidelines without qualification and in an ultra litigious landscape, that will mean that courts are constantly involved in accessibility cases, and there will be so much litigation around accessibility, because plaintiffs' lawyers, as we've already experienced with web accessibility litigation over the last several years, plaintiffs' lawyers are going to look for ways to construe where a website would not be compliant with the law because they would not meet these technical standards. And so plaintiffs' lawyers will seize upon this opportunity to require strict conformance, and then get into these situations where even if a digital asset truly is accessible and mostly conformant with the Web Content Accessibility Guidelines, they will construe ways in which it is not, because plaintiffs' lawyers are focused on why there would be an accessibility issue instead of whether access is ultimately provided. So there are realities and practical implications from this proposed bill that must be acknowledged and accounted for. This is not as simple as incorporating these technical guidelines, because as I have illustrated, there is much more to these technical guidelines than just binary, have we met this or have we not. Many of these success criterion, if you are, or the success criteria, if you are to play them out, are arguable whether or not they've been met, even if you have in good faith attempted to meet these different success criteria. Moreover, sometimes you can be in non-conformance and yet still have a very accessible website. So it's definitely possible to be WCAG 2.1 AA conformant, but it is very easy to be non-conformant. So there are any number of ways that you could potentially be non-conformant, because there are so many different considerations that we need to make, and there are any number of ways that we can fall just short of conformance. One last thing, WCAG conformance is not perfect. So while it is an excellent standard, and if you are WCAG conformant, you have done a tremendous job. But WCAG conformance still allows for sliders. It still allows for pop-ups. It still allows for autoplay media. And these can present accessibility issues. These elements can present accessibility issues, elements or conditions. So it's important to keep that in mind, that while these technical standards are very useful, they are technical standards. They were not meant to be strictly applied in the law. And so effectively requiring compliance with technical standards is problematic. So we want to, there needs to be nuance around the law. I do believe that you have to embody many of the principles, or all of the principles in the Web Content Accessibility Guidelines, but you have to do so with nuance and the understanding that plaintiffs' lawyers are looking to take advantage of this situation, as they have shown us over the last several years, that they are willing to take advantage of this area to initiate litigation, even where in scenarios and situations where litigation is not necessary, or a website is mostly accessible or provides meaningful access, but may have a few accessibility issues. So this is important to keep in mind with any new legislation.